Okay, thank you, and good morning to everybody. I'm joined this morning by my colleagues, Caroline, Richard, Tim, and Nicola. And between the five of us, we're going to cover an array of different topics. So first of all, I'm going to just talk you through a bit of a reminder of the duty, look at some reasonable steps that businesses now need to take, and any implications if you don't comply. Caroline's going to talk you through the case law, so some of the more recent cases that we've seen. Tim is going to update you on the Employment Rights Bill and what changes we foresee sort of impacting sexual harassment. Nicola's going to talk you through the sort of implications on your commercial contracts and the things you need to think about there. And then finally, Richard will pick up with talking about sort of assessing risk for your business. So a quick reminder of what the statutory duty is. So as I've explained, we had some changes last year, and it always helps to look at the statutory duty, which I've popped up on the screen. Now, the first thing I always say whenever I talk about sexual harassment is it continues to be a really, really difficult topic to talk about. And why is that? Well, it's really simple. When you look at the definition that's on your screen there, we're talking about unwanted conduct that's of a sexual nature that violates dignity, creates intimidating, degrading, humiliating environments. It's the types of behaviours that we'd like to think in 2025 just wouldn't happen anymore. But of course, we know it does because it's so widely reported in the press. So that's why sexual harassment continues to be a difficult topic to talk about. You'll see from the definition that's on your screen, it's quite a broad definition. So providing there's been something that's unwanted, that's of a sexual nature, and somebody is upset or offended by that, that behaviour or treatment is likely to constitute sexual harassment. So why is it so important? Well, first and foremost, we all want to create cultures that are free from any types of harassment, in particular sexual harassment. It impacts people's mental health if we don't deal with it, well-being. You can decrease morale in the workplace, productivity is impacted, and people can go absent as well. It's also important to say that anyone can be the subject of sexual harassment. So it can happen to men, it can happen to women, and it happens to people of all sexual orientations. So whilst it's more prevalent against women, and that's what we tend to see reported, it does happen to all different people. Intention, of course, so a perpetrator's intention behind the behaviour is often irrelevant. And it's a really good reminder just to keep thinking people don't often set out intentionally to upset their colleagues, violate people's dignity. So intention tends to be irrelevant. You just have to deal with the impact of the behaviour. The other reminder I just wanted to give you was that one-off acts still constitute harassment. And just be mindful that we are in sort of a time where we've got lots of different generations in our workforce, and people have got different tolerances. So, you look at that definition and you just have to think, well, actually, if somebody is offended by something that's of a sexual nature, it is likely to meet that definition. So what changed last year? Well, the government introduced a new proactive duty that said you now have to take reasonable steps to prevent sexual harassment in your workplace. It's not optional, so all businesses are caught regardless of your size. And it's basically not just limited to preventing sexual harassment of employees by employees. It's a duty to prevent sexual harassment of your employees and your workers. So the impact of this, although the legislation doesn't specifically deal with it at the moment, is that third parties are caught in that businesses have to take steps to prevent third-party harassment of workers and employees. So think about training. If you're training your staff, should you be opening this up to a wider audience that might include contractors? Look at your signage, and Nikki's going to talk to you later about your commercial contracts and the sorts of things that you might want to put in there. So we often get asked about, well, what is a reasonable step? And what is reasonable, it's important to say, does vary from business to business. So the Equality and Human Rights Commission has got some really good and quite specific guidance on their website, some of which is sector specific. So sorts of things like making it clear that you've got a zero tolerance to sexual harassment and ensuring that that's communicated through your workforce. Look at your environment. Are your policies and your procedures clear? Dealing correctly, obviously, if you get complaints, and obviously making sure that you prevent sexual harassment happening again. So as I've said, what is reasonable does vary from business to business, and they will take into account, so this is the tribunal or the Equality and Human Rights Commission, they will take into account the size and the resources available to your business. Of course, in contrast to that is if you ever do find yourself subject to a sexual harassment complaint and compensation is awarded, they do not at that point take into account the size and resources available to your business when awarding compensation, but they do take it into account when looking at what's reasonable in terms of the steps you take to prevent harassment. So on the screen, I've got some examples. So, making sure you've got proper procedures in place, they need to be properly communicated, reviewing your policies, obviously making staff aware of their obligations, as well as the implications, providing training. And we've said this a few times, I know, but making sure you've got staff awareness training as well as additional training for your managers and your supervisors who need to have that additional level of understanding what to do when they have a complaint. Staff surveys, really important, so that you can make sure that you act on any sensible initiatives that are proposed by your employees. And finally, whilst it's a preventative duty, sometimes businesses can do all they need to do to try and prevent harassment, but you can still get a complaint. So you need to be able to deal effectively with any complaints that arise. So it's not generally a one size fits all. It's quite important for me to say, the nature of the work that your business does means that you will be presented with different types of risk. So, for example, it's quite important for you as businesses to look at what your work is, what, for example, the frequency of dealing with third parties looks like. Look at what steps you can take and try and assess how much or how much of an effect that step will take to drive down harassment in your workplaces. So we haven't seen much case law as yet, or any case law, in fact, in terms of what would be a reasonable step under the duty that came in last year. But of course, what we do have, and what we've had for many years, is an all reasonable steps defence. So if you ever had to defend a claim, there is a defence that basically says if you've taken all reasonable steps, you as the employer will not be held accountable, and it would just sit with the individual perpetrator. So we know from the case law there that things like training that's over 2 years old will not satisfy the duty to take this is an all reasonable steps for a defence at the moment, but we've seen that. So it's just really important to stay on top of everything and make sure that you constantly update and review. So how is the duty being enforced? The Equality and Human Rights Commission have specific enforcement rights, so they can attend at your places of work, they can do investigations, they can issue unlawful act notices and action plans, and finally they have the obligation, they have an ability to issue fines, which we understand are unlimited. The one example that I've seen reported back in March this year was that the Equality and Human Rights Commission wrote to all of the McDonald's restaurants across the UK, setting out that basically if they failed to take reasonable steps to prevent the sort of sexual harassment of their staff, then they were going to face legal action. And what they helpfully did was basically set out to all those restaurants that particularly in relation to a sort of a hospitality sector, that they needed to undertake regular risk assessments. They needed to ensure that their younger and more vulnerable workers were protected and were safeguarded. And they needed to ensure that when they had complaints, that they dealt with those complaints effectively and followed a proper process. So it fits in nicely, that example, with when I said to you, it's not always going to be a one size fits all. Different types of businesses, different sectors will have different risks, and therefore what those reasonable steps look like will be different. And then the final point, I'm just thinking, what does this mean? How is it being enforced for businesses? Yes, the Equality and Human Rights Commission have enforcement actions that they can take, but you're also always going to be left with, if you end up with a complaint in an employment tribunal about sexual harassment, if you haven't dealt with and you haven't complied with your positive duty, you can see a 25% uplift on tribunal awards for sexual harassment, remembering always compensation is unlimited anyway. And that final point, that when I spoke about reasonable adjustments, reasonable steps and what they might look like, just remember we still have the defence there. So the defence says if you take all reasonable steps to prevent sexual harassment, then it's a complete defence. Your business won't be liable, but the individual perpetrator might be. So it's another really important thing just to be mindful of moving forward. And so over to Caroline to talk about the case law.
Thank you, Lauren. As Lauren had mentioned, we haven't got cases that have worked their way through the employment tribunal systems yet under the new case law, but we do have some very useful cases that we can draw some interesting some interesting views as to what the employment tribunal's perspective will be. I do a lot of advice along with Lauren and her team in terms of doing sexual harassment training to prevent sexual harassment happening, but also work with individuals who've been accused of sexual harassment, and quite often the employers take a standard view and quite often go to dismiss them automatically for gross misconduct. Now, with this particular case, the Nuns and Windermere and Wilson case, you may have seen this in the press. It was picked up by lots of the broadsheets, and the Daily Mail loved it. And the headline was with regards to the Victoria Wood song, which, if you didn't watch a lot of BBC television in the 1980s, you mightn't be familiar with it, but it was a rather bawdy, risque song. With this, the individual, he brought claims against his employer and the general manager for sexual harassment. His claims were successful. All of the headlines talked about the particular song that was sung, in which his manager apparently was looking him in the eye while making quite risque comments from the song, which clearly he felt really uncomfortable with. But there was a lot of physical touching. He touched his knee, he also touched his bottom, and Mr. Nuns tried to do everything correctly. He raised grievances. He appealed when his grievances were not upheld. And as Lauren had said, in terms of one of the tools that we can use as employers is taking grievances very seriously. This is an internal dispute mechanism that we can use to show that we are taking these concerns seriously, to investigate, to listen and learn, and to work for solutions. Also, it might help us address and find areas of risk, areas that we are vulnerable, but we can be proactive and solve them for other individuals as well. Also, to pick up another comment that Lauren had made, it's really important here. The chef was male and he was being sexually harassed. Now, the vast majority of cases I see, there's almost always a power dynamic, a power discrepancy. And also the norm that I see in terms of sexual harassment, usually it is a male accused of sexually harassing a female. That's the norm. But it does happen with men as well. And we need to be very careful in terms of our approach in terms of training and dealing with sexual harassment, that we recognise that. With this particular case, the gentleman was awarded approximately £80,000. Now, if the 25% uplift had been applied, obviously that would take us up to six figures. And one of the things that I think is really important here is that the individual who is being subjected to this harassment, who tried to solve it internally, he sued not just his employer, but the manager. And that is something which I find is a really useful tool if individuals and managers and people realize that there is a personal liability and responsibility, that if they do not follow the company's policies or do not undertake the training and don't comply with the rules, they will not only risk being named and shamed in an employment tribunal, but also in terms of any press, but also there will be a financial penalty for them as well if they are found to have sexually harassed somebody. And I think that's really important, and quite often that message is not getting across to people. Now, what I would say about this, in my experience, this very overt, sexualized type of sexual harassment that Mr. Nuns had experienced is not the norm in my experience. Over the last couple of years, the sexual harassment cases which I have been dealing with have been more in the blurred lines, so to speak. Somebody has gone to the pub with a colleague and has hugged them to say goodbye, and that has made somebody feel uncomfortable. Somebody has pecked somebody on the cheek to greet them, and that has made them feel uncomfortable. And one of the points that Lauren has picked up, that the test for sexual harassment is very subjective and it is a very low bar. Also, one of the typical scenarios we see is pecks in the cheek, hugs, physical contact. Obviously, that's can make people understandably feel very uncomfortable. But kisses on messages, kisses quite typically we would see in WhatsApp messages. I did training with another law firm, and one of the associates said she was really disturbed to see X's and zeros at the end of the messages from her supervisor. She said she had to look it up to try to understand what this meant. And then she said she couldn't comprehend why her manager wanted to kiss and hug her. She just, from her background and her generation, she was just really shocked and found this really abhorrent. So that's something that we need to be careful in terms of the cultural approaches and also the different generations as well. And with WhatsApp, quite often it can be easy to be lured into being more informal than we would be perhaps in a more formal email. So they're the typical scenario. The nun situation is not, thankfully, not a very common situation. In this case, AB versus grafters. AB accepted a lift from a colleague. She'd missed the scheduled transport, and halfway through the journey, the male colleague told her her shift had been cancelled. She'd asked to be dropped at the bus stop, and he proceeded to harass her. She then brought a claim against her employer. At the start, the employment tribunal said, listen, this is outside the normal scenario. There was actually formal transport. The work had, the employer had set up a formal transport for her to get. They didn't envisage, they couldn't have envisaged that she would have been picked up by a colleague, got an informal lift, and then sexually harassed. The Employment Appeal Tribunal took the more typical approach. They said actually the legal test is whether it's in the course of their employment or an extension of their employment. And with this is a really tricky area for us as employers and advisors, because the outside work scenario, there is an obligation for us as employers to ensure that there is a safe working environment for our colleagues if they go for informal drinks, as well as if they go to the summer party or the Christmas party, or they go for a work conference. Now, the danger scenarios that quite often there are in the same way that the grafters group couldn't have envisaged that she was going to be collected and that sexual harassment was going to happen. The types of scenarios that we need to be mindful of is that informal birthday drinks that are organised by colleagues during working hours, and they go to a restaurant or a bar afterwards. Or if there are informal trips to the theatre or the football and sexual harassment happens there. Or one of the big things that almost always is a real danger area are things like work or informal ski trips. If a group of colleagues go on holidays together or go on a ski trip, that's really difficult to try to do a risk assessment for. And there will be question marks as to whether that's an extension of their employment. The employment tribunals will look to whether it has been organised inside working hours, what the relationship has been like, and they will look at various different factors to try to determine if the informal work drinks that haven't been organised by a manager and aren't being paid for are an extension of employment. And that informal drinks, things like that, usually are. We also need to be careful of things like informal WhatsApp groups. Again, these are things that you can't regulate, but they could very easily be somewhere that sexual harassment could happen. And finally, the case at Clark versus Marks and Spencers. Mr. Clark was dismissed for sexual harassment. He had leaned against a colleague, leaned against her side and her back, and made some comments and called her pretty and priceless. She said that she felt frightened and concerned. Mr. Clark was reported to the police. He was arrested, but it was dealt with as a community order. And he was dismissed for gross misconduct. But what the employer didn't factor in, that Mr. Clark, they knew he was autistic. Now, one of the things that we are all having to be aware of is that I think the current figures are that between 15 and 20% of the population are neurodiverse. If an employer knows that an employee is neurodiverse, if they are autistic, they need to factor in this into the decision when they are looking at reasonable adjustments for any investigation or for the disciplinary. And also it may be necessary to get medical advice. For this particular situation, the employer was aware that Mr. Clark was finding it very difficult when his shifts were moved about. This caused him stress, and something that he dealt with when he was at home, when he was extremely stressed, was to seek physical contact and lean against his parents. Marks and Spencers were aware of these triggers, were aware that he was autistic, but didn't factor this in and didn't do reasonable adjustments in terms of the investigation. And they found that his dismissal for gross misconduct was discriminatory and also unfair. Now, we have seen recently that people have been, there was a lot of press in relation to Greg Wallace, raising that he was neurodiverse with regards to accusations in relation to his behaviour. But this is a real issue that we need to address and consider when we are looking at sexual harassment. There are competing rights and interests here, but we need to make sure that we look at the individual who has been who's experienced the sexual harassment, and also the rights of the individual, and if there is any if they are neurodiverse, and make sure that we don't look at it and judge it as a neurotypical type interaction. So with that, it will always be really important to get medical advice when we're making decisions.
Great, thank you, Caroline. So over to Tim to talk about the Employment Rights Bill.
Thanks, Lauren. Morning, everybody. Okay, so we have this juggernaut that is the Employment Rights Bill hurtling towards us. And, you know, we're in the HR community. We know that there is a lot to take on board when the Employment Rights Bill comes into effect. If what I've heard is right, it may well get passed as an act next month, but let's see. So what I want to look at today is whether or not there's anything in the Employment Rights Bill that actually affects the sexual harassment provisions in employment law. And the answer to that is yes, there is. There are four main areas in which sexual harassment will be affected by the Employment Rights Bill, the ERB. The first one is that the more onerous duty on employers to prevent sexual harassment. Secondly, there's going to be changes to the third-party sexual harassment regime. There's going to be implications for whistleblowing claims in relation to sexual harassment, and there's also going to be implications in relation to non-disclosure agreements. Okay, so this first area of change, this more onerous duty on employers to prevent sexual harassment. As Lauren mentioned, we're currently in a position where we have to take reasonable steps to prevent sexual harassment in the workplace. So that is going to be changing. That is going to move to a position, a much more onerous position, where employees have a positive duty to take all reasonable steps in the workplace. Now, you may remember that there was the Worker Protection Bill that was argued about in the Commons a few years ago. Should they have the word all in or not? It was taken out when the sexual harassment regulations came in last year. But there's been a lot of pressure from the Labour Party to put the word all in, so that the obligation on employees is much more onerous. If we think even further back than last year, we go back to 2013, there was actually much more onerous obligations under the previous sexual harassment obligations. When is this obligation going to come in? Well, it's going to be in, if the timeline is to be believed and the bill makes its way through Parliament in a timely way, it's going to come in October 2006. So we're going to move from the current or reasonable steps to prevent sexual harassment to a more positive duty to take all reasonable steps to prevent sexual harassment. Lauren talked about whether there's any guidance. Well, is there any guidance as to what all reasonable steps looks like? Unfortunately, the answer is no. So where do we look? We look at when the guidance might be coming out, and the government said sometime in 2027, which is not that helpful, given the obligation looks to be coming in October 2026. So, okay, where do we then look? Well, we do know that the new Section 40B of the Equality Act, which is what the Employment Rights Bill is amending, gives a little bit of guidance as to what the government is thinking in terms of all reasonable steps. They talk about things like carrying out assessments of a specified description, likely to cover risk assessments. They talk about publishing plans or policies. That's likely to cover action plans and sexual harassment policies. They talk about steps relating to the reporting of sexual harassment. And they talk about steps relating to the handling of complaints. Now, in short, I think we know all those things. Okay, we know we should be doing those at the moment. So how are we going to get a bit more guidance as to what this all reasonable steps looks like? Well, I think we need to look a little bit deeper, and we need to look at what the all reasonable steps defence under the current Equality Act looks like. So, as a quick reminder, there is a defence under Section 1094 of the Equality Act at the moment that says, in relation to any protected characteristic claim made against you, any form of discrimination claim made against you, you can run the all reasonable steps defence. Now, it is not that often run because it's pretty hard to prove. But we do have a bit of guidance from the Equality and Human Rights Commission on what this all reasonable steps defence might look like. Now, anybody who's attended the regular HR hubs that we run will know that I'm a great fan of the Equality and Human Rights Commission. I think some of their documentation, which you can find on their website, their guidance and their technical guidance is actually very good. So I would encourage anybody, if you have any query or question about practical implications of discrimination, to have a look at the Equality and Human Rights Commission. But what do they say about this all reasonable steps defence? As I said, that covers all areas of discrimination. Well, they've produced technical guidance on this all reasonable steps defence, and I think it's very helpful for us looking ahead to the new obligation to take all reasonable steps to prevent sexual harassment in the future and in the workplace. Why do I think it's useful? I think there's a couple of bits, really. There's the first one is, and I'm going to read from this technical guidance. It says the all reasonable steps defence is a requirement to take preventative steps. But we know that. The fact that an employer has taken steps such as an investigation and disciplinary action to deal with the harassment after it has occurred will not be sufficient on its own to avoid liability. So let's just let that sink in for a minute. These are the steps we're taking at the moment. We're investigating, we're disciplining, we're trying to make sure it doesn't happen again. But what this technical guidance from the Equality and Human Rights Commission is saying is it needs to go further. This guidance emphasises that we need to learn from previous harassment. So we need to, we need to see what's happened in the workplace, and once an investigation into harassment has taken place, we then need to go a step further, and we need to implement strategies to learn from that harassment and put it into our policies, put it into our training, and put it into our thought processes about how we can adapt, how we can get better as organizations to make sure it doesn't happen again. It's that learning from previous harassment, and it's that implementation of strategies, which is where I think the guidance, when we eventually get it from the government and updated Equality and Human Rights Commission guidance, will take us. So my suggestions: be proactive in stamping sexual harassment out. We know that. Continue with the risk assessments, continue comprehensive training, but keyly constantly monitor effectiveness of the measures you're taking and learn from previous instances and adapt to those instances. Okay, so third-party harassment. You may remember that back in 2013, third-party harassment was repealed by the then Conservative government. So as Lauren referred to, we do have some legislation at the moment about third-party harassment, but importantly, that legislation doesn't give an employee the right to actually go to a tribunal and claim against an employer. The only implications of third-party harassment we have at the moment mean that the Equality and Human Rights Commission can actually take action against a company if they think they are guilty of not putting steps in place to prevent third-party harassment. So in relation to third-party harassment, which is going to be introduced under the ERB, we've got similar wording coming in. Employers will be under a duty to take again, this is a similar wording, all reasonable steps to prevent third-party harassment. It's really key to point out that this all reasonable steps to prevent third-party harassment doesn't just apply to sexual harassment. It applies to all the relevant protected characteristics. So it's age, it's race, it's disability, it's sexual orientation. Because you can see sexual harassment being a common form of third-party harassment, but you can also see things like gender reassignment, sexual orientation being areas in which people may be susceptible to bullying, harassment, and dreadful treatment by third parties. So employers will need to be mindful of what happens in the course of employment. And I'm not going to spend too much more time on this because Caroline has just talked about that and given us some really good examples of what is in the course of employment. But we need to think about what's in employment, what's out of employment. In the work, in the office, in the warehouse, in the factory, clearly in employment, but what's out of employment. We're going to have to be more proactive about what is in the course of employment, because tribunals have showed us they are prepared to push those boundaries. What is a third party? Well, a third party is somebody who is someone other than the employer or the employee. So that's pretty broad. That can be non-executive directors, that can be consultants, that can be agency staff, that can be contractors, that can be people we bring in outside to help us with our businesses. It's important to know that, and if those who can remember the third-party harassment legislation that came in previously, it was effectively the 3 strikes rule. There was only a liability if there were 3 instances of third-party harassment. That's gone. It's now 1 strike and you're out. So if you fail to take all steps to prevent third-party harassment on the first occasion, you are potentially going to be in tribunal writing out a check to an employee. And importantly, there is no knowledge required. So you didn't actually have to know that third-party harassment was taking place in your office, your warehouse, your businesses. There are certain sectors, such as retail and hospitality, where a lot of issues have been raised around opinions, political beliefs, and overheard conversations. How far does an obligation of an employer go to protect people in the workplace if they work in a bar, for example? Now, there's been a lot of debate in Parliament about free speech versus protection of employees. For example, people in a pub should be able to say what they want without somebody overhearing it and taking umbrage at it and then taking action against their employer for not protecting them from hearing that comment or whatever it might be from that person who's having a pint in a pub. We haven't yet got any guidance on what this third-party harassment is looking like, but we have heard from the government during the numerous readings of the ERB. We've got a little bit of an indication about what may be coming down the track. The government have actually stated in the second reading of the ERB that the expectations on employers in respect of preventing third-party harassment will be lower than the expectation in terms of preventing harassment of an employer's own employees. So I think we can take a bit of comfort from that. We're going to have to wait until we get more guidance from the government or the EHRC. So some practical steps. Ahead of the introduction, we should be thinking about adding wording into our contracts with third-party suppliers. And Nikki will come on to this after me. We should be asking other businesses for details of their sexual harassment risk assessment and prevention measures if our staff are going to be working on their premises. We should be looking at training for managers and how to respond to third-party harassment. We should be looking at policies and training of staff on third-party harassment and how to look out for each other and speak up. It has been suggested that in certain sectors like hospitality and retail, companies may want to start to think about putting in place ask for Angela type schemes. These were introduced in pubs If people felt vulnerable in a pub late at night, for example. We're looking at signage on premises, and we may be looking at adding policies to our website to say what our policy is about third-party harassment. So those people we deal with are very clear that we don't accept it. We have a very clear policy about what we will be doing in relation to any harassment we see of our staff. Okay, so again, like the general more onerous obligation to prevent our own staff, the third-party harassment will be coming in October 2026. So we have a little bit of time to prepare for that. Okay, so what about whistleblowing? Well, whistleblowing simply is going to become a protected disclosure for an employee to report. So sexual harassment will become a protected disclosure. So it will be a protected disclosure for an employee to report that sexual harassment has occurred, is occurring, or is likely to occur. So immediately, that individual who believes sexual harassment has taken place against them, they will have the initial protection of the protected disclosure legislation. It will still need to be in the public interest, though, in order for that employee to bring a claim in the tribunal and succeed. And all the commentary I've seen at the moment said in many cases it might actually be quite hard for that individual to clear the public interest hurdle and actually succeed in a claim. We don't know when the bill will come into place, but as I said, we think it may come in next month. Whenever the bill comes in, this whistleblowing and the extension to the protected disclosure list will come in with it. Next slide, please. Whistleblowing and non-disclosure agreements. So because sexual harassment will become a protected disclosure, we have to understand that terms to stop disclosures about sexual harassment will be void in our employment contracts, our service agreements, our settlement agreements, and our non-disclosure agreements. We should be familiar with that, with the other forms of protected disclosures. But now we need to understand that when the bill comes into place, it will be void to prevent somebody raising issues about sexual harassment in all these forms of agreement. Okay, I'm going to hand you over to Nikki now, who's going to talk to you about third-party harassment and commercial contracts.
Lovely, thank you, Tim, and good morning, everyone. So third-party contracts, these are increasingly being used to reflect organisational values. So your ESG, your environmental, social and governance obligations, we're seeing more and more of these being embedded into agreements, which shifts them from your internal policy statements to enforceable legal terms. And sexual harassment prevention can be approached in the same way. So as my colleagues have mentioned, the Equality and Human Rights Commission guidance confirms that the duty to prevent sexual harassment of workers does extend to the third parties, and that would include your customers, contractors and your suppliers. And whilst under the current legislation, there's no specific employer liability, the guidance reflects the broader expectations around employees taking proactive steps to safeguard their workforce, even if that risk originates externally. So as Tim pointed out, the Employment Rights Bill is going to shake things up a bit here and introduce liability for employers in relation to third parties if they fail to take all reasonable steps to prevent that harassment from occurring, and this could be significant. And while employers can't directly control third-party behaviour, they might be able to influence it through their commercial contracts. And these contracts serve not only as a compliance tool, but also as evidence of an employer's proactive approach to risk management. So next slide, please, Lauren, thank you. So what can employers do to mitigate the risk, comply with current duties and address the draft legislation? Well, where third-party risk has been identified, and my colleague Rich will be coming on to that shortly, employers should be looking at incorporating targeted anti-harassment provisions into their relevant third-party contracts. So compliance with statutory, ESG, other obligations more generally are commonly being brought into commercial contracts through obligations to comply with policies. On their own, those policies are not legally binding on third parties, but you could introduce contractual terms to include specific obligations to make those policies and codes of conduct enforceable. clear expectations around behaviour. It requiring suppliers, third parties to undertake their own risk assessments in relation to your staff, and training expectations you might have of them, that can be set out in contracts too. The scope, of course, of any specifics there will vary considerably from one contract to another, depending on the risk factors that have been identified for the relevant third party and the nature of the contract itself. And what happens if an allegation is made, and what would be the consequences of the breach of those policies? It could be that a breach of an employer policy should give an employer a right to terminate that relationship with that third party, particularly if a zero tolerance approach wants to be reinforced and clear standards set. Third parties might not agree, particularly if we're talking about minor breaches. They may say that would be a step too far. Further things to think about are, what happens if an allegation is made in practice? You might want to suspend services if it's a customer involved, or you might want, if it's a supplier, to ensure that the individuals involved are no longer involved in that piece of work, for example, pending further investigation. And your contracts can clearly set out what happens to leave you in a very clear position as to what would need to be done. Further protection like indemnities can be included. This would cover any damages or costs that you might incur if there were allegations of sexual harassment by any of your suppliers or their personnel in relation to your own staff, and that can deal with some of the financial implications there too. And what's appropriate will need to be considered on a case-by-case basis, as I say, taking into account the broader rights already under those contractual terms and the assessment of the risk involved. As my colleagues have mentioned, hospitality and retail are some higher risk sectors with more robust measures perhaps being needed than low contact environments. And in some cases, formal contracts won't exist, and employers might need to then rely on alternative methods to communicate their approach, such as things like notices in booking confirmations or signage at premises. But where formal conditions do exist, employers should be thinking about including appropriate wording reflective of the relevant risk profile in its terms and conditions. And whilst ignorance of contractual terms is not an excuse for non-compliance in business-to-business contracts, employers should be taking care still to ensure that those changes to terms are clearly communicated and validly incorporated into those third-party contracts. If they're not properly incorporated, then they can't be enforced. So clear communication is key. We've been talking so far about imposing obligations on third parties you're contracting with, but what happens as well if you have obligations imposed on you in relation to your suppliers, your customers? And it's a case of making sure that if you've got any subcontractors in your supply chain and you have obligations imposed on you, in making sure those are flowed down appropriately. This will ensure consistency through the supply chain too, and everyone knows what will happen if something were to go wrong. For existing and long-standing contracts, any changes would likely require a more formal agreement, and amending terms, whether it's to reflect changes in the law, business needs or operational realities, there's typically a sort of formal documented written process that needs to be undertaken, as with any arrangement. In a collaborative low-risk relationship, parties might be more flexible and open to informal discussion, but in heavily regulated sectors, that might be more difficult. So the approach to be taken in each case should be considered. So finally, just to wrap this up, in terms of practical steps, it's reviewing current contracts, looking to introduce obligations to comply with policies and making sure they're communicated, make sure terms are clear, and the government focus on this area and trends more generally, show that this is likely to remain a priority for contracts.
Thanks, Nikki. So I think given the comments this morning, we know how important the risk assessments are going to be. So over to you, Rich.
Thanks, Lauren. Thanks, Nikki. Yeah, so I'm just going to spend the last bit of the session before we take any questions on thinking about risk assessments. Tim's already mentioned that the Equality and Human Rights Commission specifies that you need to carry out a risk assessment. Clearly, if there's a duty to prevent harassment taking place, and you've got to show you've taken reasonable steps or all reasonable steps when the duty becomes more onerous, you're not really going to be able to say you've taken all reasonable steps unless you've looked at the risks in the first place. You've done an audit, you've assessed those risk areas, and you've taken some steps to show that you're trying to prevent harassment taking place. So it doesn't have to be complicated. There's no sort of set form for carrying out an audit and a risk assessment. But what you don't want to do is sort of think, well, let's think of the obvious situations where sexual harassment is going to occur. Christmas party, always top of the list, isn't it? There's bound to be some issues there. Summer party, any situations where there's alcohol involved, and maybe we know that recently we've had some banter going on in the warehouse, in our manufacturing environment, for example, and so that's one of our other areas of risk. Now, all of those areas may well be areas that you need to incorporate into a risk assessment, but it goes a lot broader than that, and you really need to address your mind to across the board in your business to where the areas of risk might be. So, Lauren, if you could just next slide, please. So that's a slide that just gives you an example of the broad areas that perhaps you need to think about. It's going to vary from business to business. We've talking to a client recently who they're really hardly ever in an office together. It's pretty much an entirely online business. So the issues that they're going to face and the areas of risk are going to be different from a hospitality environment or a manufacturing environment, for example. But broadly speaking, a lot of these areas will apply across the board to most businesses. So as you can see, quite a lot to think about. Next slide, please, Lauren. So third parties, we talked a fair bit already about third parties. Tim and Nikki have both covered the issue around third party harassment. So a few practical things here just to think about when you're working through your risk assessment. So who are the third parties we're talking about? Clearly there may be clients or suppliers that we might want to, or contractors or suppliers that we might want to change our business to business terms for, as Nikki mentioned. But we may also have customers or clients who come onto our premises. We may have employees who go off and visit our clients' premises. So they're sort of one step removed from the workplace, and they're interacting with our clients and third parties in a different environment. So there's a whole host of things that may be relevant, and as I say, it will probably vary based on your business. So practical things might include things like signage on company premises, clearly policies and training, obviously, and agreements with third parties. But as I think it may have been Tim mentioned earlier, it's always worth analysing what's happened in the past. So not just looking ahead and thinking, okay, we know that we have employees who go onto the client's site, so that's an area of risk. What's happened in the past? Have we had examples or challenges, which most businesses will have probably had at some point or another, where there's the potential for harassment to have taken place, or we actually had a harassment issue? How do we learn from that? So that's really important. So that's third parties. Social functions, we'll have the formal work events, with the Christmas party, we'll have informal work events. So if people go out, after work, for example, for some food or a drink, or a group of people go and do a social activity straight after work. Alcohol is clearly an issue. Do we have a practice where we tell everybody to behave and we train people on it, and then we tell everybody it's a free bar and go and enjoy yourself? So we have to think alcohol is always going to be an area where there's probably greater risk. So we need to think about how we analyze those risks and what we do. It's not just workplace events though, not just events that we organize. So what about going off to, employees going off to a client event or a conference or a networking event? Those are all things. Now, some of those areas may be harder for us to control and manage, but nonetheless, there are things that we need to think about when we're doing our risk assessment. Work-related travel. So Caroline obviously mentioned that earlier in relation to the grafters case, slightly unusual one, that one. There will be the more obvious scenarios, where employees are required to travel for their role, or you have situations where the group of employees will be traveling together to work or to an event. But then there might be more ad hoc situations, as Caroline mentioned earlier with the grafters case. Now, you cannot plan for everything. You cannot cover every single scenario that might happen. And you wouldn't, for example, presumably want to say, to try and deal with the grafters issue, that employees aren't allowed to give other employees a lift, if they've missed the bus. Clearly, that's not going to be a sensible option. But nonetheless, again, just thinking as part of your assessment, what are the obvious areas of risk, and how are we going to try and minimize them? Online communication. So, historically, when we talked about sexual harassment, we were often talking about physical harassment, as Caroline mentioned in one of those cases earlier, but clearly it's just as big a risk around harassment these days in terms of online communication as it is from a face-to-face perspective. So looking at your areas of communication within the business, Outlook, phones. It's got text on the slide there. Does anybody text anymore? I don't know. It's all WhatsApp, isn't it? Teams, Slack, the other sort of channels of communication. Sometimes those channels can be quite informal. So maybe emails are sometimes written in a slightly more formal way than perhaps I've seen. I know clients who use Slack as a communication channel for staff, and it can often be very quick, short communications, but quite informal. Maybe there's slightly more risk there of and often it can be between small groups of people. How do we manage that? How do we sort of keep an eye on what's going on in those conversations? What guidance are we giving people? And do managers or supervisors have the confidence to deal with these issues and know what they should be doing when they do see something online which is not as it should be? Next slide, please, Lauren. This may not obviously apply to everybody, but actually I was talking to someone in the office yesterday who said, well, whatever environment you're in, at some point somebody's going to be on their own, aren't they? Or they're going to be in there's always going to be someone who leaves the office last, or one or two people left in the office on their own, and there's always going to be someone who gets in first thing in the morning. But there will obviously be areas and workplaces where a person is working on their own or in small groups on a regular basis. And often when you have smaller groups, there can be, it's harder to see what's going on. It's harder to understand when an issue is perhaps evolving and you're not able to keep an eye on it. So again, lone working, small team working, we need to think about how we can adequately address that. Next slide. I'm conscious we're getting towards the end of our session. So Caroline mentioned this earlier on, really, really good point, that a lot of these situations arise from situations of power imbalance. And often, sometimes similar to that, there might be a power imbalance within a personal relationship. So people have personal relationships at work. How do you deal with that? Do you have a policy in relation to relationships at work, for example? There's no legal obligation to have a policy, but as Tim mentioned earlier, if you don't train people and introduce policies so that people know what we expect and require of them, then it's going to be quite hard to then explain to a tribunal that we've taken all reasonable steps to try and prevent harassment if we haven't sort of made it fairly clear to people what is, what we expect of them, what's the right thing to do and what's the wrong thing to do. So have a think about things like power imbalances and relationships at work and whether you need any sorts of policies on that. And finally, culture. Sadly, and I'm not the only person on this call who's seen plenty of these sorts of cases over the years, where sometimes there are organisations where people feel that it's very hard to challenge an existing culture of banter, harassment, everyday sexism, etc. So how are we going to deal with that? How are we going to change the culture? How are we going to make people feel safe to put their hand up or to report something without the fear of any consequences coming from it? And that's the reason that, as Tim mentioned earlier, the whistleblowing rules are going to change so that not only so that someone is specifically protected from a whistleblowing point of view if they do raise a concern around harassment, but that in itself, a legislation change clearly isn't going to cut the mustard. What are you going to do to try and identify those areas within your business where there is perhaps an existing culture of banter or sexism, and how are you going to address that? So that's, as we're 1 minute past 11, I will stop there and hand back to Lauren.
Thank you, Richard. So hopefully that's been a useful session for everybody, and thank you to all my colleagues for joining me this morning to talk you through the different issues. I hope everybody leaves not thinking it's a complete minefield, but sort of been able to break down the real issues that we have here, not trying to make it complicated, but equally for each of your organisations, really looking at what your specific risks are. We are here to help. So after this session today, we'll make sure we circulate the slides, the recording, and also some information on some of the services that we can offer to help you with your risk assessments, with your training, and with reviewing your contracts. So we'll leave you on that note. Obviously, we have to say, we know you can't have a zero tolerance to banter and jokes in the workplace. You can, however, have a zero tolerance to sexual harassment. You can look at the risks that are really specific to your businesses and take appropriate steps. So thank you, everybody, and enjoy the rest of your day. Thanks.
Bye-bye.